It's certainly a ruling that is going to impact every DUI case.
Channel 2 investigates a legal trick that has drunk drivers getting key evidence against them thrown out by arguing they were too drunk. And we learned they can still go to trial and plead not guilty later. Channel 2's investigative reporter Jody Fleischer is here with how it works and the impact it's had so far. Jody?
It sounds ridiculous to win a DUI hearing by arguing you were too hammered to legally consent to take the breath or blood test. But we've tracked more than half a dozen cases where that's worked. It's all because of how judges are interpreting a new Georgia Supreme Court ruling, and it has prosecutors reeling.
Sir, have you been drinking tonight?
This popular public service announcement declares war on drunk drivers.
Over the limit, under arrest.
But proving a driver is over the limit isn't as easy as it used to be. Breath and blood tests are getting thrown out of court because the drivers are convincing judges they were too drunk and not thinking clearly when they agreed to take the voluntary tests.
You would think that that's absurd, right? Nobody would try that.
But they are, and they're winning. We found blood alcohol concentration tests kicked out by judges in Fulton, DeKalb, Cherokee, and at least 5 cases in Gwinnett County.
The defendant wasn't actually capable of informed waiver of his constitutional rights.
Attorney Lance Tyler was the first to win this argument for his client, John Williams. The case went to Georgia's Supreme Court and created what are now called Williams motions. They're filed in almost every case.
If a DUI defense lawyer is not raising the Williams issue, I frankly think it's malpractice.
Attorney Mike Hawkins doesn't see it as a legal trick, but a sound constitutional argument.
Think about consent in any context. It has to be knowingly and intelligently given.
Which he argues you can't do if you're hammered. A Gwinnett judge threw out this driver's .225 blood test, noting he also had a pretty good accident, which could have rattled him.
But I need a yes or a no to this.
A yes or no to what?
Will you submit to the state-administered chemical test of your breath under the implied consent law?
I mean, f it, man, why not?
I told you, sir, I am a little bit confused about English.
A judge also threw out this DeKalb driver's breath test because his English was poor and he couldn't clearly understand.
I don't have this in any language but English. All I can do is read it for you again, and then I'll need a yes or no answer.
Judges also take into account whether the driver understands that what the officer is asking is voluntary.
What I'm asking you to do is take the official state breath test. Do I have to? I can't give you any legal advice on that, yay or nay. I can reread this for you.
That test got thrown out too.
Think of those first words. Georgia law requires you to submit. If I'm told by a police officer that I'm required to do something, you can bet that in all likelihood I'm going to feel pressure to submit to the test.
Gwinnett County's solicitor says she will not dismiss cases just because her best evidence got thrown out. In fact, she's appealing 6 of them.
It is difficult. These days, juries watch CSI. They expect scientific tests.
And she isn't allowed to tell the jury what happened with the test, even if the driver eventually goes to trial and pleads not guilty.
Oh, it is frustrating. I think anybody who values the truth is frustrated not to be able to reveal the truth.
Now, in a few cases, the drivers already pleaded guilty or were found guilty of a lesser charge, but most of these cases are still pending in the courts. Prosecutors say without those tests, they'll have to depend on officer testimony and dash cam videos if they have them.
So, of course, we're getting a lot of response to this on our Facebook page. People are talking about it and commenting. And some people argue that it makes sense when you think about other aspects of the law.
Well, that's very true. I mean, if you think about it, the courts have ruled a contract invalid if the person was drunk when they signed it. Judges check to make sure a defendant is sober before allowing them to plead guilty to a crime. But you can agree to a search while drunk as long as the judge finds that you understood your rights.
But if someone hurt your family member, this would make you sick.
The Mothers Against Drunk Driving and families are totally outraged over this.
Yeah.
Jody, thank you.